So what's on tap for today, folks, is another reaction video of mine to one of our favorite senators out there, Josh Hawley of Missouri, who's going to be questioning a nominee for the Department of Justice, and he's questioning on her Second Amendment cases. So let's get right into it, but before we do, just want to let you know you're watching the Dr. Nasir Sheikh Show. If it's the first time you're around here, I'm your guest host. My name is Dr. Sheikh. And if you haven't already done so, subscribe to the channel, hit that notification bell, like and share and follow us on this video. You know what to do. Let's get right into Josh Hawley questioning Julia Kobick.
Ms. Kobick, if I could just start with you. Let me ask you a question about the First Amendment, if I could. Does the First Amendment apply to the medium of the internet, in your view?
My understanding is
1791.
Well, Senator, the Supreme Court has adopted a number of different tests for assessing the constitutionality of different provisions. The First Amendment protects speech, of course, and people speak on the internet, but I would adhere to...
Wow, thanks for letting us know there, Attorney Julia Kobick, that people do speak on the internet. I think we all knew that.
The relevant test if any First Amendment case were to come before me.
Well, I ask you because the Supreme Court has said something much the same in the Second Amendment context. And in the Second Amendment context, you argued to the Supreme Court that because a particular firearm did not exist at the time of that amendment's ratification, that it wasn't covered. The Supreme Court, covered by the right, that is, the Supreme Court rejected your opinion unanimously in a per curiam opinion. That's the Catano case. I've got it right here. You've been asked about it. You know, what's interesting to me about this case is there's a lot of division on the United States Supreme Court about a lot of topics, including the Second Amendment, but they were unanimous in this case. It's a very short order, 2 pages, not even, really, page and a half, in which they rejected your argument completely out of hand. And I just want to ask you, why did you make an argument that the Supreme Court said held no water at all, so much so that they felt the need to address it in a per curiam decision and to remand the case, saying that the arguments that you made were not to be countenanced at all? You didn't get a single vote. So tell me.
The reason why she didn't get a single vote, and as Senator Hawley says, is a per curiam decision, unanimous 9-0 verdict at the Supreme Court, basically saying, listen, lady, what you're arguing has been argued in the past. We didn't accept it back then. We're not going to accept it right now. It's a stupid, lame excuse. It has no merit, has no bearing whatsoever in what you're trying to do. But the reason why she's trying to do it is because she is a zealot. She is she's not an advocate for the Second Amendment. She is an opponent of the Second Amendment. She doesn't want us to have the right to bear arms. She doesn't want guns in the hands of legal United States citizens. She wants to take it completely out and leave it up to the government to decide who gets and who doesn't. That's who this person is. You're dealing with a person, folks, who is absolutely, anti-Second Amendment.
Help me understand, why did you make arguments that the Supreme Court said had previously been made and previously rejected by the same court?
Thank you, Senator. I just would like to clarify at the outset that I did not handle the Catano case when it was before the Supreme Judicial Court. The case was handled by the district attorney rather than the Attorney General's office at that stage. In the Supreme Court, the argument that I made...
Wait a minute, you didn't, the Catano case at the U.S. Supreme Court, you didn't handle it?
I did co-author the brief in opposition to certiorari at the Supreme Court,
okay,
but not the Supreme Judicial Court. I'm
asking you about the Supreme Court, the Supreme Court judgment that rejected your arguments. So you just confirmed, I think, that you made those arguments to the United States Supreme Court. Is that correct?
Respectfully, Senator, the argument in that brief was slightly different. The argument
doesn't answer the question at all. Doesn't answer the darn question at all. A simple question. Did you or did you not write the brief? Co-authored it. Yeah, I did, but it wasn't at the Supreme Court level. It was the Supreme Court judicial level. I mean, this is unbelievable. These guys, well, they're attorneys. They know exactly the gobbledygook that they can speak, this legalese speakies, so they can sort of, go around everything without really having to go at it directly.
Was that a stun gun is, we argued on behalf of the Commonwealth, not an analog to a founding era weapon.
Which the Supreme Court rejected unanimously.
The Supreme Court held that the Supreme Judicial Court had misstated the Heller decision in 3 respects. But again, I didn't handle the case in front of the Supreme Judicial Court.
So your argument is that your position wasn't rejected unanimously by the U.S. Supreme Court?
I certainly acknowledge, Senator, that the Supreme Court summarily reversed the Supreme Judicial Court's decision. I would adhere to the Supreme Court's holding in Catano and reaffirmance of Heller's statements.
No, she won't. She's lying through her teeth. These people want to be activist judges. They want to be activist attorneys. They want to get the judgeship. They want to get on, into the courtroom so that they can legislate from the bench. That they can make the laws themselves if they see fit. That they see fit. If they don't like a law, they'll get up there as a judge and they'll change it. And they'll use whatever power that they have to do it.
What I'm trying to understand, the Supreme Court was very dismissive of your arguments. One of the reasons it was dismissive is it said they've considered these arguments before and rejected them. This is why they then rejected your arguments per curiam unanimously. So I'm trying to understand why someone who has ethical obligations to the court, why you would make arguments that the court has previously rejected, knowing that they'd previously rejected them. And then here's the other thing that interests me. In this case, the person who had been arrested under this law that the Supreme Court then reversed on was the victim of domestic abuse. And I just want to read a few of the facts here. This is from Justice Thomas and Justice Alito's concurrence in that per curiam judgment. Here's what they say.
On most vacations, you take a trip.
That's from the trial record. With an abusive boyfriend that put her in the hospital, Jamie Catano found herself homeless and in fear of her life. So she obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, she accepted the weapon. And it's a good thing she did. Because one night, after leaving work, Catano found her ex-boyfriend waiting for her outside. He started screaming that she was, this is from the trial record, not gonna effing work at this place anymore because she should be home with the kids they had together. Catano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. She stood her ground, displayed the stun gun, and announced, I'm not going to take this anymore. I don't want to have to use the stun gun on you, but if you don't leave me alone, I'm going to have to. And the gambit worked. The ex-boyfriend got scared, and he left her.
Folks, thank God that this lady had a stun gun. But what this lawyer was arguing, what she was basically doing is that lady didn't have a right to have a stun gun because guess what? Stun guns weren't around back in the time of the founding fathers. They weren't back around 100 years. So guess what? If a gun wasn't back then, around then, guess what? Doesn't matter. The only thing she cares about is, if you got a Winchester or a flintlock. That's what this lady is arguing. That because these guns were not around at the time that the Constitution was written, at the time of the Founding Fathers, that they should be excluded from the Second Amendment on those grounds. Thank God that this lady, Katana, had the stun gun given to her by a friend. And for this lady to go after her, or for this lady to ask for them to basically ask the court to not review this case, in essence is the same thing as taking the gun out of this person's hand. It's unbelievable what these maniacs are doing.
Alone. You think she shouldn't have had the right to self-defense?
Senator, thank you. Again, the district attorney made the decision to bring charges in the Catano case. The Attorney General's office and myself were not involved in that decision, but I certainly recognize
that you argued for it to be upheld before the United States Supreme Court.
Senator, the argument in that brief was that the Supreme Court should deny review of the case.
Right, which deny the right of self-defense to this person. I'm asking you why.
Senator, my duty as Assistant Attorney General was to represent the Commonwealth in that case when it came to the Supreme Court, and I did so consistent with my ethical obligations.
Your duty is not to make frivolous arguments to the Supreme Court of the United States. And frankly, I question your judgment in what you did in this case, and I question your judgment in choosing to try and perpetuate what is manifestly.
I mean, again, folks, she says her duty also is to protect the citizenry. That's also her duty. She could have easily basically have said, you know what? I'm not going to accept this case. There was other people that were out there. Somebody else can take it. But it just goes to show you what is at the heart of these arguments. These people want to get rid of the Second Amendment. If they could, want to get rid of parts of the First Amendment as well. These are zealots. All of them within the deep state of the bureaucracies in government. And what they want to do, and that's what happens, folks. These are lifetime appointments, usually. Lifetime appointments. And once they get there, their tentacles, they get stuck in the wheels, in the halls of justice, and start to bring it to a grinding halt, and take away the rights of every normal day American citizen. Slowly and slowly, what these guys are trying to do is strip away our rights, little by little. They don't try to grab big chunks. Or sometimes they try to go ahead and grab those big chunks at a time. But they know also that if they just go slowly and chip away at it, over time, they'll be able to go ahead and erode those rights that were given to us under the Constitution of the United States of America. And that's why we've got to be able to not nominate these people. We've got to have the power of the Senate back. So when these appointees come from, presidents like Joe Biden or Barack Obama, or, whoever there is in the Democratic Party, and even sometimes maybe if we happen to have a rhino Republican as a president, a moderate, Republican, and put some people up there that have sketchy details in terms of the background, what they think of like Roe v. Wade, Second Amendment, First Amendment, property rights, all kinds of things. We've got to make sure that they are people that are based sound on the originalist interpretation of the Constitution, and that they have conservative legal briefs and cases as precedent, so you can take a look at what they've done, what their thought process are, what papers they wrote, so that we only appoint conservative-minded or strict originalist of the Constitution to these judgeship positions. Well, folks, we thank you for watching here on the Dr. Nasir Sheikh Show. If you haven't already done so, subscribe to the channel, hit that notification bell, like, share, and follow us. And I've been your guest host for today here on the Dr. Nasir Sheikh Show. My name is Dr. Sheikh, and I'll leave you with my final thought, which is, when you're right, you're right, and when you're left, you're wrong. We'll see you again next time, folks. Take care and stay safe.